Vietnam has become a hub for international business and foreign talent. However, hiring foreign employees is not a simple HR task. It is a regulated legal process. Every step, from position approval to work permit issuance, must comply with Vietnam's regulations on foreign employees. Many foreign companies unknowingly violate these rules, resulting in heavy fines, rejected permits, or even deportation of their expatriate staff. In Vietnam, good intentions don't protect against non-compliance, documentation and process do. Understanding the common mistakes employers make is the first step toward hiring safely and legally. Vietnam's labor law requires employers to justify the need for foreign employees before hiring. Vietnam's labor regulations on foreign employees define the procedures for obtaining approval, work permits, or exemptions. Employers must also ensure that each foreign employee's job title, qualifications, and experience meet the position's requirements. The process involves 3 key stages: 1. Labor demand approval, 2. Work permit or exemption issuance, and 3. Labor contract registration. Missing any stage exposes employers to penalties of up to 150 million Vietnamese dongs and suspension of work authorization. The most frequent and costly mistake is hiring before obtaining labor demand approval. Every employer must submit a report on the demand for foreign workers to the competent labor authority at least 15 days before hiring. This report justifies why the position cannot be filled by a Vietnamese worker. Many companies skip this step, assuming it's a formality. In reality, without this approval, any work permit issued later can be invalidated. LTS law always begins every foreign hire process by securing this foundational approval to ensure all subsequent filings are valid. Job title consistency is critical. The position in the labor demand approval must be consistent and substantively identical to the title in the work permit application, the labor contract, and the immigration documents. Inconsistencies, such as project manager in one form and regional manager in another, often lead to rejection or delays. Each job title must reflect real responsibilities and align with the applicant's qualifications and experience. Using overly broad or unrealistic titles is one of the fastest ways to fail an inspection. Foreign degrees, work experience letters, and criminal records must be consular legalized, translated into Vietnamese, and notarized before submission. Many employers rely on uncertified digital copies or forget legalization altogether. Authorities will not process incomplete or unverified documents. Even a small omission, like missing an embassy stamp, can reset the entire application timeline. LTS law helps clients manage legalization efficiently across multiple jurisdictions, ensuring no document is rejected at the Vietnamese consulate or the competent labor authority. Work permits must be filed at least 15 working days before the employee starts work. Many companies begin the process too late, assuming extensions are flexible. They're not. Late submissions can result in administrative fines and forced suspension of work for the foreign employee. Furthermore, working without a valid permit, even for one day, is considered illegal employment. Employers should plan at least 30 to 45 days in advance of the expected start date. LTS law provides a structured compliance timeline to ensure no deadlines are missed. Some foreign employees may qualify for work permit exemptions, such as investors, board members, or intra-company transferees, but exemption is not automatic. Employers must still file an exemption dossier and obtain a work permit exemption certificate, WPEC, from the competent labor authority. Many companies skip this step, assuming exemption means no paperwork. This misunderstanding often leads to fines and visa issues. Proper filing and approval are required for legal recognition of exemption status. Labor contracts with foreign employees may be signed in English. However, for compliance, inspection, and dispute resolution purposes, a Vietnamese version is required. Vietnamese authorities, labor inspectors, and courts rely on the Vietnamese text when reviewing employment relationships. If a contract exists only in English, employers may be required to provide an accurate Vietnamese translation, which can delay procedures or weaken the employer's position during inspections or disputes. Best practice is to use bilingual labor contracts, clearly stating that the Vietnamese version prevails in case of inconsistency. After a work permit is issued, the employer must submit a copy of the signed labor contract to the competent labor authority for record purposes. Many companies forget this final step, leaving the employment technically unregistered. Without registration, the work permit may be considered inactive. HR teams should keep signed, stamped copies and submission receipts for every foreign employee. Work permits and exemption certificates are valid for up to 2 years and renewable once. Employers often lose track of expiration dates or fail to renew on time. This oversight results in non-compliance penalties and project disruptions. Companies should maintain a foreign labor compliance register, tracking expiry dates for permits, visas, and TRCs. LTS law provides clients with a customized workforce compliance calendar to automate reminders and renewals. When a foreign employee leaves the company, the employer must return the work permit to the competent labor authority and cancel the temporary residence card, TRC, within 15 days. Many companies overlook this, leading to complications in future applications. The company may even remain listed as the employee's sponsor in immigration records. Proper offboarding protects both the employer's compliance record and the employee's immigration status. Some companies delegate the process to unlicensed service agents who lack legal authority or knowledge of current regulations. These agents may submit incomplete or falsified documents, exposing the employer to legal penalties. Always verify that your legal representative or service provider is a licensed law firm with experience in labor and immigration law. LTS law, as a fully licensed legal practice, ensures every filing meets current Vietnamese regulations. A Korean manufacturing company in Binh Thuong was fined for employing 2 engineers without valid work permits. LTS law reviewed the case, worked with the competent labor authority to regularize labor demand approvals, and secured exemption certificates for eligible staff. The company's fine was reduced, and its compliance system was rebuilt to prevent recurrence. Within 6 months, LTS law's guidance helped the company pass a full labor authority inspection with 0 findings. At LTS law, we manage the complete foreign labor compliance process, from eligibility review and work permit applications to exemption filings and renewals. Our bilingual lawyers prepare all documentation, handle legalization, and liaise directly with the competent labor and immigration authorities. We also conduct internal compliance audits and HR training for multinational clients to prevent violations before they occur. Hiring foreign talent can strengthen your business, but only if done legally. Avoid the mistakes that cost companies time, money, and reputation. Contact LTS Law today for expert guidance on hiring, managing, and retaining foreign employees in full compliance with Vietnamese law. Stay compliant, stay confident, and build your global workforce the right way, with LTS Law by your side.